Get that as case number 110111 in the matter of Robert A. Mintz.
May it please the court. The Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, I'd ask for 2 minutes for a rebuttal.
2 minutes is granted.
Thank you. In this case, the standard of review is that this court must accept the findings and conclusions made by the hearing panel if those findings and conclusions are supported by clear and convincing evidence. In this case, the panel's findings and conclusions are not supported by the uncontested evidence. As this court is aware, the formal complaint contained 327 allegations, out of which the respondent stipulated or admitted to 326. Those admissions included the fact that on January 30th of 2012, police were called to J.A.'s apartment at 11:21 a.m. after he had called 911 to report that he had found her body. What he did not tell law enforcement was that he had actually found her 3 hours earlier. And in that intervening time, he made the conscious decision to alter the scene, to delete evidence, to move a vehicle, all to conceal the fact that he had been with her the night before and engaged in heavy drinking. He then proceeded to lie to law enforcement about his activities and about the way that the scene looked. He knew what he was doing at the time was wrong. The panel made the conclusion that the respondent, quote, knew that he should have been honest with the investigating officers. In this case, the respondent did engage in dishonest conduct. He provided false information to the investigating officers in his first statement to them. The panel also concluded, quote, that the respondent's reaction to the situation was a completely human reaction to an emotionally charged situation. The panel found that the respondent's conduct was an isolated incident of dishonest conduct, which he realized was wrong and corrected within a short period of time. The panel then went on to conclude that because this had nothing to do with the representation of a client, that there were no rules violations, and they ordered the complaint to be dismissed.
I don't read the panel's conclusion as being that.
Pardon?
But I don't read the panel's conclusion as being just based on the fact that it was outside the practice of law.
No, that was another factor. There were all three.
They do seem to adopt the District of New Jersey view that you cite to, I think, as well, that it is only those acts that are of such gravity that they impact the fitness of the person to be an attorney. And it seems to me they conclude that that's not the situation here. So several questions
Sure.
Flowing from that. First of all, do you think that is the standard we should apply?
Whether it is approaches fitness.
Yes. Where do we draw the line between any dishonest act? I think that Mr. Ambrosio gave us some examples that might, be clear at the far end of a spectrum of such minor day-to-day kinds of conduct that nobody would question it, to the obvious that we've had in many cases, stealing from a client or, a long-term theft operation or con operation, any of those kinds of things are so obvious none of us would question it. How do we draw the lines along that spectrum?
Well, in this particular case, I don't believe that we need to figure out where that line is. Does the disciplinary administrator's office recognize that there is a line? Yes. And I want to make clear that
Is there a line?
Yes.
You think so?
Well,
in for a penny, in for a pound, you lie, and I see it affecting the sanction or affecting whether your office exercises its discretion or the review panel exercises its discretion to docket a complaint or just send a do-better letter. But why isn't being dishonest regardless of the degree?
Well, I think it depends on the context. Mr. Ambrosio in his brief gave the example of a lawyer lying to their dentist about flossing. Does that really impact on somebody's abilities? Is that something that goes to their moral core or their ethical core, which as lawyers we're required to take? I don't think it's our office's business.
How do you get that from the rule? The rule says engage in dishonest conduct.
I agree with that. But as far as what you're talking about, I don't believe it is the office of the disciplinary administrator's business to be involved in the personal affairs. For example, in this case, if the complaint had come in and it had been from J.A.'s husband at the time saying that she was engaged in an extramarital affair with another lawyer, under our rules, unless that is a lawyer's having sex with a client, I don't believe it is our business to become involved, even though that is technically dishonest conduct. Or if the family had sent us a complaint saying that she was in treatment and he was taking her out drinking, I don't believe that that goes to what we need to. In this case, why it is before this court is because of the impact of lying to law enforcement. A lawyer, I think there is your bright line as far as this case goes. A lawyer simply cannot lie to law enforcement when they are conducting an investigation. They cannot delete potential evidence. They cannot alter the scene of an unattended death, and that's where the distinction lies. Whether or not that goes to the fitness, that I think is up for the court. That was not charged. 8.4G was not charged because the reading and the research kind of indicated that a lot of those cases were analyzed through the practice, through the view of the practice. 8.4C and 8.4D neither have a requirement that the conduct has to be related to a client or to the practice. And in this case, it's clear that he did lie, and it's clear that he did have an impact. Even the panel found that his conduct had a minimal impact on the investigation.
Was the scene initially treated as a crime scene, or do you know? You said it was an unintended death. How did they know it was unintended until there was an investigation?
What in the record, according to Mr. Mintz, when law enforcement arrived, they explained to him that they were going to have an investigation because it was unusual that a young woman would be found dead. And that they needed to look into, because sometimes people can have a suicide, sometimes people can have a homicide that is made to look like a suicide, and so they were going to look into it. And that was right when the law enforcement arrived.
That would be true of any unattended death.
I would presume so. I honestly don't know.
Right.
Did I answer your question, Justice?
You answered my question, the first question. The second question is the panel's conclusion that this did not go to the respondent's fitness as an attorney, or that's probably not the way to say it, as you've pointed out, given the rule that was charged. But anyway, in essence, their adoption that this was not the type of act that they felt discipline was appropriate. Is that, in your view, finding of fact that we would, where our standard of review is substantial competent evidence? Or do you believe that's the conclusion that we reviewed de novo?
I believe that was a conclusion, and I believe that the way that they reached both of the conclusions as far as the rule violations was that they inappropriately applied mitigating factors in determining whether or not there was a rule violation. I believe the process should be, one, is there a rule violation? And then two, what is the appropriate punishment? And that's when you talk about mitigation and aggravation. And in this case, they made specific findings. They made findings of dishonesty, and they made findings that there was an impact upon the investigation. And I believe both of those are sufficient to support this court finding the rule violations. Then the next question is, what were the appropriate aggravating and mitigating factors? And the factors that they applied were that this was a completely normal human reaction to an emotionally charged situation, which we dispute. A normal human reaction to finding somebody that is in...
But did they really go through the process? I know they talked about it, but when you dismiss for finding no violation, have they really gone through the process of determining the most appropriate sanction? And what I'm getting at is, do we perform that duty, or do we remand it and say, no, we don't agree with your factual finding, it wasn't supported by the evidence doesn't support your conclusion, so finish it up. I mean, that's what we would do in a criminal case.
Correct.
If there was a dismissal at preliminary hearing, we would send it back and say, go forth and finish the process. And do we do that, or do we go ahead and finish it for the panel?
I believe that because we argued aggravating and mitigating factors at the hearing. All of that record has been developed. And the last time our office actually appealed a case was in 1994, and in that case, the panel dismissed at what I call halftime, after the presentation of the bulk of the evidence. That was appealed. This court found that the panel incorrectly dismissed, sent it back for those further proceedings because the record had not been developed. But in this case, both parties had ample opportunity, and we were able to present all of the factors, both aggravating and mitigating, to the panel. Whether the panel considered those is not part, because they determined at the first part they did not need to go further. But I believe that this court has definitely the authority to be able to determine what type of punishment is the appropriate result.
Even though that requires fact-finding?
Well, it's application of the standards.
Your assertion is they've already found the necessary facts and that they did not react appropriately based on those facts?
Correct.
Okay.
But is that really true if we go through the aggravating factors? I mean, just take even, for example, prior discipline. It may be undisputed, but there hasn't been a finding regarding that, has there?
No.
And do you think in that light that every aggravating factor was undisputed? And every mitigating factor was undisputed? Or is there disputed evidence as to any that may influence any factor?
It is my recollection that there was nothing that was in dispute. It was an interpretation of how this incident should be viewed and its application as to the practice. It was the disciplinary administrator's office that deceitful, dishonest conduct towards law enforcement equates to disbarment, because you cannot fix dishonesty and deceit and fraud. And it was their position that this had nothing to do with the practice of law. And I believe that's where the panel went, that this was something outside of the scope. Did that answer your questions? The entire record, if you look at it, it shows a general pattern of repeated omissions and minimization on the part of the respondent. If you compare each response that he gave throughout the disciplinary process, the interview that was conducted by Special Agent or Special Investigator Terry Morgan, his actual live testimony, and then finally his interview with the police detectives, there are significant omissions all the way through until we got to the police interview. The respondent admits that every one of his actions was done for his benefit. And even if this court determines that his actions were motivated to deceive J.A.'s family, once law enforcement got involved and he made the decision to lie to them, that's when the rules become implicated. Disbarment is appropriate when a lawyer's conduct involves intentional deception and the deception was done for the benefit of the lawyer. And disbarment is appropriate in this case. Thank you.
Do we have any further questions of counsel before she sits down? Thank you, counsel.
Mr. Chief Justice, Your Honors, may it please the Court, John Ambrosio on behalf of the respondent. I want to answer Justice Luker's question first, because I've really wrestled with this. If this court finds that there should have been discipline meted out, the only case I can find is the Ehrlich case, where this court sent the case back to the panel to make a decision about what the discipline should be. There has not been any fact-finding about discipline. The panel said there was no violation, plain and simple. If this court determines that in this advisory opinion the panel was wrong, then I think you have to send it back for that same panel to make a decision on what discipline is meted out. That's my view of this, but that's only because I can't find any cases that are even in keeping with this anywhere.
And we have to send it back to the same panel?
I think so, but there's a problem because one of the members is no longer a member of the Board of Discipline. He got off in July. But I think since they heard the evidence, there's no reason why that same panel can't be appointed to make a decision on what discipline should be meted out, whether it be an informal admonition or anything else.
What facts are really in dispute, though?
There are no facts in dispute. We admitted everything. The only slight argument was whether or not my client fessed up and was honest with his criminal lawyer within 24 hours, which is our thought process, and the disciplinary administrator that said it was 48 hours. I think that was the only disagreement as to the facts, the actual hard facts.
What about the facts having to do with aggravators and mitigators? Are any of those facts, the existence of any of those aggravators and mitigators actually in dispute? Because you've
No.
asserted that it has to go back. Why does it have to go back if none of
Because
them
I
are in
think the
dispute?
panel, I believe that the panel has to make that decision in its advisory capacity to this court. Obviously, Your Honor, this court can do whatever it wants. I've never had a case like this before. So this is all new to me.
I just want to make sure I understand. You're saying that none of the existence of any of the mitigators or aggravators is in dispute,
Correct?
but nevertheless, we would, if we should find that there were violations, conclude that there were violations, we would need to send it back to the panel to determine facts on undisputed evidence?
What discipline should be meted out? Because this court,
We decide discipline. They only
I
make a
understand that.
recommendation.
I understand that.
That's a recommendation about a matter of law.
I understand that also. I feel it should go back to the panel who heard all of the facts, heard the evidence, saw the witnesses. They describe in that report the way my client appeared, how depressed he was, how hurt he was after 16 months, I think is what they said. Hence, they're the ones who should make the determination and recommendation to this court, not this court in a cold way determine what should be meted out. That's my opinion.
I don't see much cold record. I thought they were pretty explicit on what they thought about the sanction, and they thought there should be no sanction and dismissed. And I mean, it's like, wink, wink, what do you think the sanction should be after you've dismissed the case? I mean, really? I mean, what is in question now about what they think should happen?
Nothing. They were pretty clear.
Well, and that's so that I'm back to Justice Myers. Why are we entering into an exercise in futility when we already know what's going to come back?
Here's the history. Your Honor, the history of the way we do disciplinary cases has changed a little bit over about the last 5 or 6 years. Before, a disciplinary panel would take a break and make a decision whether or not there was a violation. And then if there was a violation, then you proceeded that same day to the aggravation and mitigation phase. Now, in an effort to move these cases and not to take 10 hours as opposed to the 3 or 4 hours, we do it in one fell swoop. And in this case, would I have offered more aggravation, more mitigation? Would my colleagues have offered more aggravation? I don't know the answer. I think everybody's correct in this case. And I think the lawyers who are appearing before you are flailing about trying to figure out what to do in this case. I am thrilled with the panel. I don't think there's any doubt that you know that I'm thrilled with the panel decision. And I agree that this was an isolated situation where my client made a terrible, terrible judgment about what he should do. But he straightened it out. He straightened it out right away. And to go and say that a lawyer who has a great, great reputation, who's been a great lawyer for years, who was involved in and none of us can describe or understand what this man went through, to say that he should lose his license for fibbing to the police.
I want to talk to you about that.
Okay.
You said he immediately fessed up, but actually he talked to 2 different lawyers who recommended a cause of action before he did anything to
That's correct.
correct the record. So it wasn't immediate. He got 2 recommendations and acted contrary to those recommendations before he fessed up. There were pieces of the falsification of the scene, destruction of evidence, moving the car, etc., that occurred after he'd already had at least one lawyer's recommendation to turn around, go back, and call the police.
Absolutely. He called Mr. McGrath first. You're right.
Right. And he called a second lawyer, and he did not react immediately to that lawyer's advice either, did he?
That's not true. That's not what the evidence shows. He called Tom Bath. Tom Bath said, get down here. Tom Bath called the police. The police could not see Mr. Bath and my client that day. The next morning, they called Tom, and they said, we want to see your client. Tom Bath immediately called my client. He left his law office, and they went down immediately. They did it as immediately as they could do it, Your Honor.
Okay. All right.
Because there was an investigation at the death scene.
Okay. But he did nothing while they were still at the scene, or
Absolutely
he did not
not.
follow
That
the
was-
advice of the first lawyer.
You're absolutely correct.
Okay.
But he moved this with as much alacrity as he was able to with the advice of lawyers.
The second time. The second time. He got advice from his law partner as he was driving away from the scene the first time.
with a former law partner who also, now, I'm not splitting hairs with you. I'm not splitting
That's
hairs.
splitting hairs, but he got advice from another
got-
lawyer to go back and call the police immediately.
And also said,
Proceeded with his
who also
falsification
said
evidence.
though, and call somebody who deals with this all the time.
Okay. But he didn't do that until after he'd done all the things that he's in trouble for.
Absolutely correct. There's no doubt about that. The evidence is clear.
Okay.
Could you address Ms. Knoll's point that it appears that the hearing panel applied mitigating factors and consideration in weighing whether or not there was a violation rather than doing that post-finding, and that's when you begin to utilize those factors in determining what the appropriate sanction should be?
Your Honor, I don't see in the record or in that panel report that they did that. I think paragraph 31 and 32,
Human reaction to an emotional situation.
that's not an aggravating or mitigating factor, is it?
It seems to talk about how that's a consideration on how you're going to view the evidence and how you're going to handle a violation. That once you conclude there's a violation, once you conclude there's a violation, you would say, but in response to that, that's a human reaction to an emotional situation, so therefore we're going to minimize what that is.
Okay, and I'm okay with that. And I think we all should be okay with that. That's why we have panels making a recommendation to this court.
Right. But that's after finding rather than utilizing that type of analysis when you're making a determination if there's a violation.
Or did they simply say, he did something wrong, but it doesn't rise to the level of an ethical violation, which I think is closer to the point and what they did. And they may have taken into effect the two character witnesses that I put on. They may have taken into effect my client's appearance on the stand.
But what would that have had to do with whether there was a misconduct or a rule violation? If he lied to investigators, what does the fact that he's a good person or that this was a normal human reaction, as the panel says, what does that have to do with whether there was misconduct? And
I think
should they, if they did consider it in determining that, should they have?
Yes, they should. I think the panel should look at everything when they make a decision on that, Your Honor.
But they have to determine the misconduct without looking at the aggravating and mitigating
Absolutely.
factors.
That's what they're supposed to do, absolutely.
So what do those things you're talking about have to do with the actual alleged misconduct?
Probably nothing,
Right.
but thank God the panel looked at them in making that decision.
But the issue we're talking about is when do they look at them?
That's correct. Then maybe we need a bright line rule from this court that says, from now on, you have to go out and make a decision on whether or not there's a disciplinary violation before you get into the aggravating or mitigating situation. Maybe we need to do that. So if they dismiss it at the end.
That is what we do. That is what they do, generally. That's
not what they do.
Have you seen another panel do it this way before? Have
Dismiss
you ever
it-
seen another panel do this where they talk about whether this was a natural human reaction to a
I can't
emotional situation
recall.
during
Your Honor, I
the,
can't
excuse
recall.
me, Mr. Ambrosio, before they have arrived at a decision on whether there's a violation? I don't have one in my memory
don't-
from the last 10 years, but you've been doing this a little longer than I, so what about it?
But you've seen more cases than I do, and I don't remember any. I agree with you on that.
Okay. You're trying to be a stickler with us about who gets to decide on undisputed evidence, which would depart from our pattern in every other case that ever comes before us. When we have undisputed evidence, we make the legal call. You've said the evidence is undisputed.
That is absolutely
So
correct.
you want us to
and I
be a
stand by that.
stickler for permitting the panel to have another crack at it, sending it back to them because they normally make a discipline recommendation. You want us to follow that procedure, but it appears to us, I think all my colleagues are asking the same question, in essence, didn't the panel deviate from its ordinary procedure here?
And I don't think so. I don't think so.
Can we go about this at a different angle? It seems to me we're talking aggravators and mitigators, which confuses things because that's part of the calculus, but in the sanction portion. What this panel actually said, quote, respondent did engage in dishonest conduct. He provided false information to the investigating officers in his first statement to them, unquote. The rule says engage in dishonest conduct.
Correct.
So what they did was found that the reason he violated the rules excuses that conduct from being a violation. And that's where I have a disconnect, because if you were in the criminal arena, you wouldn't say, oh, well, it wasn't a crime because it had a real reason to do it, unless it's a lawful defense. But it would factor into the calculus of the sentence that the judge would impose. Like your little white lie, if you stole some, shoplifted some bubble gum, you're probably not going to prison. That kind of thing. But I don't see how we can say that the panel can use the reason for the violation to find there was no violation, rather than to use the reason for the violation as a factor in the sanction to be imposed. Does that make some,
Yeah,
do you
it's a
understand
lot.
what I'm saying?
Yeah, you've taken it away from being a paradigm and made a logical progression through it. The agony that I have, Justice, is this is completely different than any case that I've ever been involved in, and I can't find anything from this court that tells me what I should have done. That's my problem. And now I'm saying you can mete out whatever justice you want. You can mete out whatever you want, but do we have the evidence before you if you say there was a violation? They meaning the panel, saw my client. They saw his emotional destruction. They saw how he acted. You didn't see that when they made their decision. I think what this panel is saying, if you lie to a judge, that's real dishonesty and you should lose your license. If you steal, you should use your license. This is different. He was scared. There was a real reason why he was scared. He was scared of the family. He was emotionally involved with this young woman. He loved this woman. They had planned the marriage, and he finds her dead, and he panicked. And he was never charged with obstruction in the Western District of Missouri or in Jackson County. He was never charged.
I hear that argument as making my point. You go, well, if you lie to the judge, you lose your license. If you lie to so-and-so, you lose your license. Here he lied to the police, but had a good reason, so he didn't have any violation. The logical argument for that is he doesn't lose his license, not that he didn't commit an ethical violation. Do you understand what I'm saying?
I understand what you said, just that I don't happen to agree with you. I don't think I made your argument for you. I just think that the panel looked at this man, they heard what he had to say, they understood why he had made a mistake, and they said, this is different than those other type of violations. That's all I'm arguing. Notice I'm down to 58 seconds, and my client does want to address the panel. With your kind permission, I'd ask him to come to the lectern.
I'll give him some time.
Thank you.
Before I begin, I want to address a question that was just answered by Mr. Ambrosio. I called Mr. McGrath on my way home. He told me that, in his opinion, the right thing to do was to go back to the apartment and call the police and call the family. That's what I did. I didn't not follow his instruction. First thing in the morning,
Excuse me, just so I'm clear on the facts. So you had already erased the cell phone record?
I had
talked to
already
Mr.
left
McGrath.
the scene, yes.
You'd left the scene, but I want to understand, you were at the scene 2 different times before the police arrived, correct? You were there originally, and you left, you went and got her car, moved it back, right?
Right.
When did you erase the cell phone records?
On the way to get the car.
Okay, so that was before you called Mr. McGrath or
Yes.
after? Okay. And when did you do whatever else you did to rearrange
All
matters
before.
at the scene?
All before I called Mr.
Okay,
McGrath.
thank you.
But you went on to your home and changed clothes after you talked to Mr. McGrath?
I was already about a few blocks away, yes.
So it was just that act of changing clothes that occurred
Yes.
after the phone call?
Your Honors, I have a number of personal regrets that I'm going to have to live with or try for the rest of my life. I know the facts in this case, although it may not be central to what we're here to discuss today. They beg the question first, how could I let Jen drink when she came back from Valley Hope, and how could I join with her? There isn't an easy answer to that. When she entered into the program, I know we were both convinced that her drinking had to have been over. We were both encouraged by the program, and I was committed to try to do everything I could to help. I was very disappointed when she asked me to take her for a drink on the way home from the program when she graduated. I said no. I was trying to be strong. She needed more of that strength from me, and I didn't give her enough. As the days went by, her urge to drink grew, and I believe she started drinking on the Thursday before she passed. When I discovered this, we had a long talk about her health, us, and I think we were back on track. We met for lunch the next day, and she again wanted to drink, and again I said no. Later that evening at dinner, she leaned in and said, "Honey, I can handle a glass of wine." You know, more than anything in my life, I regret saying yes to her. She needed strength, and I didn't give it to her. The truth is that Jen was vulnerable and weak, and I was too. I regret personally and feel very sorry for what I did, especially to Jen. I regret that when I found her passed away, I had a complete breakdown of personal judgment. I was totally shaken. There aren't any words to describe what it was like to find her like that. And I don't have any words today to tell you how I feel. Before I could collect myself, I was in a complete panic because I knew that members of her family would likely want to harm me, because if they determined that I had been with her and let her drink, they'd hold me responsible. That was my state of mind. I don't think I was entirely in control of what I was doing, and I don't think Jen's family would have been entirely in control of their emotions either. I was told to stay away from her funeral or I'd risk harm, and that was before any of this came to light. I had no intention to try to deceive authorities. I had no understanding that it could ever be considered a crime scene. I wanted to tell the detectives while I was there, then and there, what had happened, that I was with her, what I had done. I was trying to shield this from her family. I never got an opportunity to speak to the detectives without the presence of Jen's family. So I left and I went home. And the next day I called Mr. Bath with the intention of wanting to get back in. I didn't want to go by myself. I've said from the beginning I knew it was wrong. I apologized to the detectives right away. I apologized to this court, and I apologized to the bar that I'm a member of. It was wrong. That's a responsibility that I own up to, and I have no excuse. I practiced law for nearly 24 years with the same firm, and in all that time, I believe I tried to adhere to the rules of professional conduct strictly. I've had the privilege of working with many distinguished attorneys, all of whom taught me to regard my ethical duties in the highest standard. I don't believe anyone has ever questioned my fitness to practice. And I think I have earned a reputation of defending my clients in an honest and ethical way. What I hope this court finds is that what happened here was a personal failure. I wasn't prepared in a human way to find Jen the way I did and to react to what was happening before I could even gather myself. I am sincerely regretful of everything that had happened. I apologize to this court, to Jen's family, to my bar. I just have to try to live with what's happened.
Do we have any further questions?
Did your practice or does your practice involve any criminal defense work?
It never has.
Anything else? Thank you both. Reserve 2 minutes for rebuttal.
I said at the beginning that the complaint contained 327 allegations, and there was one that was not agreed to, and that was when he went in for the second police interview. And the court has the record before it. It's undisputed that on January 30th was when the 911 call, and in the record there is the DVD of the police interview that is date stamped February 2nd. And I determined that it wasn't worth fighting over because he didn't immediately, which was our argument, go in and correct his statement. He was in a police car by himself with a detective at the scene. He left the scene about 3 in the afternoon, could have called law enforcement from his home, and he chose to do that. As far as his claims that he believed that he was in peril, the only testimony that was offered during the hearing as to the danger presented by the family was there was a telephone call made by J.A.'s stepfather because J.A. had not called her mother. And the stepfather indicated that the family was going to go to the respondent's house. And when asked what that meant to him, he said he really didn't know. The second incident was that he was going to go out of town with J.A., and the family didn't want him to accompany her, or they didn't want her to accompany him.
Ms. Newell, when was this call placed by the stepfather?
They were coming back from Wichita. It was before she went into treatment.
Oh, okay. All right.
And then the second event was that an aunt allegedly told J.A. that if they left, that the family would go to his law firm. And again, when he was asked what that meant, he said he didn't really know what that statement was implying. Any
further presentation? Any more questions?
I'm just in the whole fitness to continue practice and the violations that you're seeing. Are you including all of that you talked about, including the conduct post Valley Hope graduation, the drinking on the plaza, the apparent driving while right after consuming massive amounts of alcohol? All of that goes into this equation in terms of your recommendation?
Yes.
Okay, not just the conduct that arose when he reacted to the emotional situation of finding her dead body?
Yes.
All of it?
Yes.
Okay, thank you.
That prompts another question for me. Is there any evidence in the hearing record or the record that preceded it of respondent having any kind of alcohol treatment or evaluation?
He was asked at the hearing if he believed that he was an alcoholic, and he said no. He also explained that the first night that they drank, I believe it was at like a pizza place, a wine bar on the plaza, that they were more happy with the wine than they had been without drinking. And there was no presentation as to mitigation as to any kind of substance abuse problem.
I'm sorry, they were more happy what? With what?
With wine than
with
without
wine.
it.
Was there any evidence as to the level of his intoxication
No,
at the night before?
no. The only statement he made was that he believed that night they were drinking vodka out of martini glasses, and then someone in the bar sent them some sort of creamy kind of shot, and then they had a glass of port that he described was being poured in a larger glass than a regular port glass, and his testimony was that he believed that J.A. drank most of the port, but and if you look at the police interview, it was pretty much shot for shot, drink for drink.
Any more questions?
The cause of death was both ethanol intoxication as a contributing factor to the cervical spine injury. Is that
That is correct.
how it was
Correct.
characterized?
Correct.
Thank you, counsel. Thank you all for your arguments this morning. Court will take this matter under advisement.